So good morning to everyone. I'm Nikolaos. Yesterday we had, I think, a very interesting first introduction into the problem of SLAPPs. But I think that what is going to follow up is going to be a fascinating discussion, even better than the one we had yesterday, because we will try to go really deep into the issue. We have three very interesting speakers. Three or four, actually, no, four very interesting speakers. Or I should say fascinating speakers, and you will understand why. So the title of the session is Advocacy and SLAPP, Protecting Journalists and Whistleblowers. I will present the four speakers, say just a couple of words for each one of them, and then they will start talking, and we will have an exchange with some questions, etc. So first of all is going to be Philipp Wissing, who is a Blueprint for Free Speech's coordinator for the new German national No SLAPP coalition and campaign. Then I will give the floor to Fotis Giannoulas, who is a Greek lawyer, a member of the Athens Bar Association, and a managing partner at Giannoulas and Associates law firm in Greece. Then it will be the turn for Thanasis Koukakis, a fellow journalist who, during the huge Greek Watergate scandal, also became a friend of mine, and I have deep admiration for him because not only he was the first you have to know about Thanasis Koukakis, he was the first European citizen that it was proven, we have evidence that he was targeted with the illegal predator spyware in Europe. And Thanasis is important in many ways. He was a reporter. He was a source for much of the reporting on the Greek surveillance scandal for the journalists that reported on that. And he is also a victim, because not just that he was a victim of surveillance, but he was also dragged into courts. He's the victim of SLAPP lawsuits, actually not even for publishing a story, but for retweeting stories that some of his colleagues wrote about the surveillance scandal. And last but not least, it will be Janine Louloudi, my colleague from Reporters United. I won't say much about what she will say, because for me it's very good news that she will present something that happens for the first time in Greece, and I'm very happy that I will be here while she's presenting that, because this is the moment we have been expecting for 4 years. So let's start with Philipp Wissing, that will make his intervention online.
Thank you very much. I hope you can hear me well. It's a great honor and privilege to speak here. And thank you also for the very kind words, Nikolaos. I hope I can be as fascinating as announced, but I'll do my best. But indeed, it's not about us primarily, but it's about those who are affected by legal intimidation. That's the topic of today. And as you already introduced me, Nikolaos, I'm working for Blueprint for Free Speech currently on a project in Germany. We are establishing the first No SLAPP contact point. So the first opportunity for those affected by SLAPP, and also for the broader public who are interested in that topic or who actually want to learn what SLAPP is, to find a place to speak to contact, to get legal help, which is nothing that we can guarantee, unfortunately, but we can help to find lawyers who are willing to support. And firstly, and then foremostly, we really want to raise awareness for this topic, which has been coming more and more all over Europe, also in Germany. And civil society has seen a rise in SLAPPs, and it's really important that we talk about that. So in Germany, we always have this attitude, or many people have this attitude a lot of times, that it's different than anywhere else in the EU. Particularly when it comes to the legal system, many people think that in Germany all is different, all is better. Particularly when it comes to SLAPP, there is this, I'd even say, arrogance sometimes of people saying, yeah, that's a problem of other European countries, which is a big mistake because, first of all, Germany is also part of Europe, so if it's a European problem, it is also a German problem. People should not forget that. But then again, we have SLAPP cases in Germany too. We know that this kind of legal intimidation And abuse can happen everywhere where a legal system is in place, which allows people with more resources than others to use and misuse the legal steps which are there to legitimately claim, for example, questions of personal representation in the public, to misuse these legitimate steps to intimidate. So we know that this is possible. Of course, it's also possible in Germany. And in my opinion, one should not focus too much on numbers when starting to dig into this phenomenon, because once we know that it's structurally possible, and once we've seen cases, and we see cases in Germany, I can say something about that shortly, it must be the priority to get to those who are affected by SLAPPs, to make them good offers to actually talk about their cases, because that's how SLAPP work. If they are effective, they will get not known, they will be out of the public. We heard it in the introduction. It's about public participation, and if there is a mechanism in place to effectively bully and intimidate people out of the public sphere, then it's absurd to ask for numbers, because if this mechanism really works, then there are not many numbers because people get silenced. So that's our starting point. We know that there's a problem. We're also part of the case of the coalition against SLAPPs in Europe, and of the local German coalition against SLAPPs, which is really important to be there for those affected by SLAPPs, to organize themselves, which is really important. I think it's a lot about community resilience, organizing itself. And out of this coalition, we started our current project, which got state funding, fortunately. And it's a powerful partnership of 6 NGOs, organizations. It's Blueprint for Free Speech, the organization I work for in this project. Sulet has been here yesterday, I think, and talked already about SLAPP. Blueprint is involved in many free speech and whistleblowing issues around the world and projects, and trying to help those affected by strategies of intimidation. And then we have Reporters Without Borders in Germany. We have the German Journalist Union, the German Journalist Association, the Transparency Organization Ask the State, and the Action Against Labor Injustice. So that's the project network. And we are hoping, we only officially launched in May last month, so it's quite new, quite exciting, everything. We're hoping to provide a good offer for those affected by SLAPP. We are hoping also to count more cases, definitely, to get more numbers in the course of our project. But we want to combine this with active help. We don't want only to count the sheeps and then people are affected and get counted, and it doesn't help them immediately, but we want to turn it around. We want to establish an offer they can take advantage from in the very situation of being affected. And then we will document all of the cases that we come across. So that's maybe the introduction to the project I'm in. I can get deeper into cases that are in our heads, also into the services we offer. But maybe, Nicholas, do you have any questions, or do you have any intermediate comments?
Are there any questions or comments for Mr. Wissing? I wanted to ask you a question, because this is something we get a lot when, I'm a reporter, I'm a journalist, and our project has been a victim of gigantic SLAPPs in Greece. Actually, we are now dragged into courts for 2 defamation lawsuits for over 3.5 million euros, when our annual budget is around 150,000 euros. But one question that we get a lot from, let's say, ordinary people that are not so much into SLAPPs is, to play a little bit devil's advocate, isn't it the right of a person who is, we report about a person, isn't it their right to sue us? Don't they have the right to go to courts and defend their personality? So why should we have a special legislation about SLAPPs? And what would be the characteristic that differentiates between a normal defamation lawsuit that should go to courts and a SLAPP?
Yeah, good question. I think it gets at the heart of the directive also and of all of the measures in place to prevent SLAPPs from a legislative point of view. I think, and that's part of one of the problems at first, that of course you can only be sure if a claim that was brought to court was abusive, was unfounded, manifestly unfounded, after the court has spoken the judgment, right? And then you also have to rely on the judges to make a proper judgment. So I think that's two restrictions that are there for a proper judgment whether something is a SLAPP 100%. But I think it is about a strategical dimension a lot, because I don't know how you experience this in your case, but we see many cases where we assume, or where we have strong indices to think that companies have their strategies, their legal strategies, and where they strategically know that they can, because for them it also costs money, right, to go to court and to claim defamatory or defamations, and they have to hire their legal team, they have to make the court case too for several months, but they have this calculation, okay, this will cost us this amount of money, but we think that it will help us to get this opponent or this critical voice out of the public, and we will be at peace, and so it's worth for us to spend $400,000 over the next 2 years. And this strategical dimension and perspective will be different if they know that there's a risk, and a quite big risk, that if in the end, after the process is over and after there's a judgment, that then someone will make the claim of this was a SLAPP. And if then we have, and we hope that we will have, strong legislation in place which has, for example, recompensation claims if it really was a SLAPP, so that it's not only that the slapper has to pay for all of the costs of the trial, but also to pay more. And if there's a real risk by that, then we hope, or I think it's a realistic prospect, that big companies, wealthy individuals will not use this so strategically anymore, because they can't just rely on, okay, we have a couple of lawyers, we have money, we can just go for it, and let's see how we can make the life of this journalist as hard as possible. But they will also need to take into account that they will maybe have a problem after the lawsuit, that they then will get the claim of SLAPP. This is a really abstract strategic level. I think it will still change something, but of course, I think that's the second answer to this question. It's important to provide more help to those affected by SLAPP than this very vague, well, in the future, if the trial is over, you can claim that it was a SLAPP, and then you will have to have another trial maybe, and it will take even longer. So this can't be all, and this is where we focus a lot also on help that doesn't only focus on this label SLAPP, which gets officially, which you can officially call once the trial is over. But we think that in the moment where public voices feel intimidated or get intimidated, they should get help, they should get community help, they should get legal help. And I think that's something that civil society needs to organize, and that's more than any legislation will probably come up with.
And any other question? Please, yes.
So can you tell us about the other 6 NGOs that are involved, and how can more NGOs get involved in this anti-SLAPP effort? Or at least when somebody has been slapped, what kind of help and support can we offer?
So I only understood the end of the question, but I can definitely say something about how NGOs or others can get involved. And if there was more to it, then just let me know.
Well, I was asking who the other 6 were. You mentioned that there are 6 NGOs.
Yes.
Who's also involved in this effort? So in case we want to reach out, we know Blueprint for Free Speech, but who are the other 5 and how can we get more involved with them?
Yeah. So the other 5 are Reporters Without Borders in Germany. Then there is the German Journalist Union in Verdi, one of the big German unions. Then there's the German Journalist Association. And there's a transparency organization called Frag den Staat, Ask the State. And then there's Action Against Labor Injustice, who focus on union busting and general questions of the public, which is constituted at work. You will find the partners also on our website, noslapp.de, and there in the About section there are all the partners listed, also with link to the websites. And it's and this is a selection, I would say, of organizations who are active in the No SLAPP coalition in Germany. So there's at first this coalition, and I think that's an approach that I would always recommend, that it's important to at first have a level of activism, of getting active, of getting organized, of individuals, organizations affected by SLAPP or willing to support those who are affected, because much of the work at the beginning is campaigning, raising awareness in an activist way, getting involved in court cases that are ongoing, right? Gathering money, crowdfunding, etc., which are things that are difficult for, or at least in Germany, for state-funded or other funded project. Depends on the funding, of course. But so this is why I would always recommend to first have a activist coalition, because I think it has, or I'm sure it has a political dimension. It's about recognition, right? We still have this discussion here in Germany where many actors, political actors, legal actors, lawyers, say that there is no problem, that this is absurd, that SLAPP doesn't make sense, because, as Nikolaos said, everyone has the right to go to court, and why making this a problem? So I think there is a lot of advocacy work need to be done everywhere, and also in the specific cases, because it is about motivating those who are affected by intimidation, by acts of frightening people so that they don't speak in the public, to motivate them to speak in the public. And I think there's always needs, at least that's what I hear from those affected, that it always needs the feeling of others fighting for a cause, and that it needs more than just, well, I can write a piece here and that's it, and but rather, okay, there's someone attacked and needs to go to court, faces really big sums of money, maybe jail time, which is not really probable to happen if the courts are not corrupt and if the case is well founded. But still, it's intimidating by itself. So yeah, I think this coalition work is important, and then, of course, the second step would be to look out for funding. In Germany, we had this state funding we could apply for, and we got it, fortunately. There are many other funders, of course, but then I would say it's important to form out of these coalitions smaller groups who focus then on really technical aspects, and that's the second thing that we do. So technical aspects, we offer training sessions so people can invite some of our experts and get training to prevent SLAPP cases by doing really good research, by not exposing themselves by any small mistakes. Then we build a big network of lawyers and legal experts. And then we are present at many other events. We're developing a guidebook, and we have a regular call where people can talk to us. So that's a rather technical side, I'd say, which is the second dimension that I would always recommend to go into.
Thank you very much. Any other question, or should we move on? Okay, so
Just a quick one. Hi, Philipp. This is Ari from Liberty of Speech. Is it my understanding that on the directive there is a clause that protects organizations that deal with whistleblowers, and due to their professional, for the jobs, to put it this way, they can get slapped? And if that happens, they are protected by the directive. And can I assume that journalists who are using sources and they can suffer retaliation due to SLAPP suits can also be protected by the directive. That is my understanding. Correct?
Yeah. So I'm not a legal expert on these questions, but my understanding is the same. And I think that every one of us journalists, whistleblowers, should really try to use these legislative tools to push for interpretations of the directives that allow as much protection as possible. So if you can rely on this in your daily work, I would ask your lawyer to be sure. From an advocacy point of view, or if you want to talk about it in public, I would definitely call for this to be true. I would definitely insist that this protection should be there.
Thank you. And may I add to that the actually burden is on the slapper to prove that his case, his lawsuit, it's not a SLAPP suit. So that's a great tool on the directive that we can use as journalists.
No, I definitely agree that we should all, get more into this directive, get to know it better, and then really try to use it as much as possible. Thank you.
Thank you very much, Mr. Wissing. I saw Mr. Giannoulas nodding on this last point by Aris, so it's the right moment for him to weigh in the argument. This is Fotis Giannoulas. He's a lawyer, he's a member of the Athens Bar Association, and he's a managing partner at Giannoulas and Associates in Athens, Greece. And my very basic question to you, Mr. Giannoulas, would be to explain to us the legal status of the anti-SLAPP protection in Greece, if there is any.
Thank you very much. Good morning, everyone. Let me start by introducing myself. My name is Fotis Giannoulas. I'm a lawyer since 2003, founder and managing partner of Giannoulas and Associates law firm based in Athens. I am also a member of the board of directors of Athens Bar Association since 2022, and I'm also honored to participate in the working group for the reform of the Greek Code of Civil Procedure, recently established in the Ministry of Justice. My approach to SLAPP suits will be more technical legal. I will try to speak as clearly as possible, being fully aware that most of you are not lawyers. Let's start with the definition. What makes a SLAPP suit be a SLAPP suit? SLAPP is manifestly unfounded or abusive court proceedings brought against natural and legal persons on account of their engagement in public participation. And when we talk about public participation, we refer to any statement or activity by a natural or legal person expressed or carried out in the exercise of the right to freedom of expression and information, freedom of the arts and sciences, or freedom of assembly and association, and any preparatory, supporting, or assisting action directly linked thereto on a matter of public interest. To put it in a nutshell, a SLAPP suit is a lawsuit that, regardless of being partially well-founded, has as its main purpose to silence the opposing party, to prevent him from taking action primarily through his freedom of expression, by which he attempts to raise and serve a matter of public interest related to the exercise on constitutionally protected rights of members of society. In order to describe a lawsuit as a SLAPP suit, we will usually see a claimant forum shopping, filing a lawsuit and successively waiving and resubmitting its lawsuit, seeking extremely large sums of money as damages, pursuing various claims in multiple pleadings. Purely procedural behavior may also be accompanied by practices of intimidation, harassment, or threats before or during the proceedings. SLAPP suits are not new. They belong to the category of abusive lawsuits. It is lawsuits whose purpose is not really to protect the claims that are theoretically pursued by them, but to intimidate the opposing party or even to send a different message to third parties. The last category is the oldest. It is the most numerous, and this is the reason why SLAPP suits can easily be concealed in the multitude of such suits, particularly in relation to the Greek legal community, which is most unfamiliar with SLAPP suits. Indeed, it is very common in Greek judicial practice that whenever an allegation is made, even in the context of a court proceeding, that could be inaccurate and cause some damage to the image of the person to whom the allegation relates, that person files a lawsuit or even submits a criminal complaint in order to indicate in a significant and forceful manner that the allegation is inaccurate. The same applies not only to inaccurate allegations, but also more generally to expressions of criticism expressed in characterizations. And the slightest potential breach of a threshold usually leads to counterclaim or even a criminal complaint. In all this multitude of such suits, we have to distinguish between those which are simply abusive suits or suits brought in excess of a reasonable standard, and those ones we are interested in here, the SLAPP suits. Only a small part of this large number are indeed SLAPP suits. The special issues involved in SLAPP suits were first highlighted in the USA in the 1960s, and subsequently the issue became a matter of concern to the European legal orders. The European Union has already resulted in 2 legal texts that set out guidance for the legal orders of the member states of the Union, a directive and a recommendation from the Commission. We will come back to this in a moment, but before we do that, it is worth asking ourselves, does the Greek legal order lack the instruments to deal with such lawsuits? And does it need to add legal instruments? The answer is both yes and no. Our national law has instruments to deal with such lawsuits. First of all, SLAPP suit is a type of abusive lawsuit, which is forbidden under Article 281 of the Greek Civil Code. The reason why the courts of our country do not have a specific approach to such lawsuits at the moment is not the lack of legal instruments, but the lack of an appropriate mentality in the legal community, and especially among Greek judges. It is the same mentality that has led our country to a very poor performance in relation to the protection by the Greek courts of freedom of speech in general. There is no culture of protecting freedom of speech in Greek courts. Greek judges do not seem to see themselves as potential protectors of freedom of expression. It seems that they see themselves as protectors of individuals from the excesses of free speech, rather than the other way around. This probably has to do, perhaps, with the reduced credibility of journalists and the way journalism is practiced in our country. Those present are accepted, of course. For this reason, we can find great strictness in judicial judgments regarding the limits of freedom of speech, with the result that even value judgments that deviate from absolute decency are punished with relative ease. It is worth pointing out that the issue of SLAPP suits is not limited to freedom of expression cases. However, freedom of expression is the basic means by which public participation can take place. It is the raising of an issue of public interest that concerns society as a whole. The national instruments therefore exist, and if the courts want to discourage SLAPP suits, this would be possible, although it is possible that these instruments would be inadequate or not as effective as would be desirable. The legal instruments introduced or proposed by the new legal text of the European Union can make us realize that the existing instruments need to be strengthened and enriched. So let's look at these legal texts. The European Commission has issued a recommendation to Member States to adapt their international legislation by proposing specific tools since 2022. The same tools have been included in the directive published some time ago in 2024. The recommendation of the European Commission is not binding in the Member States and contains proposals for the adoption of national legislation for cases of a national, domestic nature, while the directive is binding on the Member States, contains specific provisions that the Member States are obliged to incorporate by 2026, and concerns cases of a cross-border nature. It would, however, be significantly contradictory for a Member State to have special rules for SLAPP suits where there is a cross-border character, and for such special rules not to apply where the parties are domiciled in the same country. The main provision proposed or introduced by the recommendation in the directive are the following. First, to provide for the award of costs or the possibility of awarding damages to claimant bringing a SLAPP suit. This point is particularly meaningful if this can be done even in the event of a partial success of the action, because in the event of defeat, the costs are in any event to be awarded to the unsuccessful party. In any case, the imposition of court costs, even on the successful party, if it is charged with abusive conduct, is already protected for in Article 185 of the Code of Civil Procedure, while Article 205 of the same code also provides for the possibility of imposing a financial penalty against a party who engages in conduct. The second legal instrument, in particular, is very rarely used. The possibility of awarding damages to the defendant in a SLAPP suit still exists today through the possibility of filing a counterclaim, alleging that the filing of the suit itself constitutes abusive and therefore tortious conduct, although this is quite rare in practice. Second, national legislation shall provide for security for the claimant in a SLAPP suit, i.e. a sum of money corresponding to the legal costs and any compensation of the defendant in case it is actually proven that a SLAPP suit is involved. A guarantee mechanism for court costs is already provided for in the current Code of Civil Procedure, but its use in practice is very rare. I personally have never seen a security for court costs. Third, national legislation shall provide for the possibility to dismiss with SLAPP characteristics, dismiss a claim with SLAPP characteristics at an early stage, i.e. before the substantive examination of the case. The decision at this early stage must be final, in particular if it leads to a dismissal of the claim described as a SLAPP. And national legislation shall provide for the possibility to appeal against it. The purpose is obviously to ensure that the very existence of the lis pendens ceases to be a cause of fear for the defendant party. It should be noted, however, that the judgment as to whether or not a suit is a SLAPP suit is not a simple judgment that can be made roughly and instantly. There is therefore a risk that we could end up with a two-stage trial, both of which could last for a considerable period of time, with all the financial and psychological damage that this entails, particularly for the defendant. A mechanism for a general early examination of a lawsuit is currently not provided in our civil procedure, but in the context of the discussion of the revision of the Code of Civil Procedure, the general provision of such a stage in civil proceedings is indeed being considered. Fourth, the directive suggests the adoption of a specific public policy clause for the enforcement in a member state of a judgment of third country, which is considered that is connected to a SLAPP suit in a member state, i.e. the possibility for the courts of that country to refuse enforcement of the judgment in the member state. The directive also makes it possible that, for a national court of an EU member state to award compensation for costs and expenses incurred in proceedings in a third country, in derogation from the general rule that costs and expenses are awarded by the court seized of the case. It is the time, therefore, for the Greek legal order to adapt to these requirements. For the directive, in theory, it still has 2 years to do so. What is certain is that the very adoption of the recommendation and the directive have the power to shape judicial judgments even before the adoption of specific domestic rules. Personally, I'm not so concerned about incorporation as such. I'm more concerned about the change in the mindset of judges, who need to see themselves more as protectors of free speech and become much more sensitive to how they react to abusive litigation and especially SLAPP suits. If this is not done, no matter how many legislative changes are made, they will hardly be implemented, just like the tools that exist today anyway and are not implemented. Consequently, the issue is the change in the mindset of the legal community and familiarization with the issue of SLAPP suits, to understand that this is a separate and distinct behavior, to understand the value and the need to address it. And in this direction, today's event is particularly useful and important. Thank you for your attention.
Are there any questions for Mr. Giannoulas?
You said that the new directive provides that the cases that are abusive must be dismissed in early stages. Is there the proper framework in Greece in order this provision to be facilitated or not?
As I said, at this stage we have not a mechanism of early examination after issuing a lawsuit, filing a lawsuit. In the committee, in the working group, we are checking if a stage like this could be in the reform of the Code of Civil Procedure. My thought is that this stage could examine some basic things, and the thing if a lawsuit is a SLAPP suit or not is a very complicated issue, and as I said before, I'm not sure that the legal community in our country can deal with a so complicated stage before the main stage of the trial. That is my thoughts about it. We have to make an effort to see. We are obliged to do it from the directive, to see how these two systems can be complied the one with another.
Any other questions from the audience?
Hi. So my question is about Greece. They're saying justice delayed is justice denied. Now, with your experience, what is the average execution of a court case from start to finished?
Generally, or in these...
well, it's a civil matter. SLAPP suits will be civil matters, correct?
Today, if we file a lawsuit for which could probably a SLAPP suit, we had the trial about December 2025. It is not very far. Most of the cases have a trial date 2 years or 3 years. I think that if I file a suit today, I could have the possibility to execute it in about 4 years.
Which executed means the court trial.
No. Execute, I mean that I could take measures in order to have not the trial. The trial is going to be done in about 1.5 years from now. potentially a SLAPP suit. But in order to have the right to have the money of the judgment, I think that I need about 4 years.
Okay, and that will be the first instance court. Don't you have appeal afterwards?
4 years, I think. I mean, after the Court of Appeal.
After, so 4 years.
After the Court of Appeal.
And that is what our concern is, that how does a person survive those 4 years?
I understand it. Yeah. Generally, I think that the delay in justice is not only a Greek problem, is a problem in all the West, I think, not in the same way in all the countries. Here, in some proceedings, things are very bad. We're trying to figure out new ways of reducing this time. It is not a simple problem. Now in the working group in the Ministry of Justice, we're trying to find ways not to have unjustified delays. I think that things in a couple of years is going to be better, not a significantly better situation.
I think I recall last year, and I speak in the correction, that there was an issue with delayed cases, and there was a judge that was dismissed because
yes,
they found,
not only one.
they found court cases lying at your place that they wouldn't have proceed.
Yes.
And we have a judgment against Greece, I think, from
Not
the
only
EU,
one. Not only one.
for delaying court cases.
Not only one. The Court of Human Rights in Strasbourg is very strict with us, and that is its duty. We have not good records in the time of having a decision. I think that the changes we are talking about are going to make some progress, but I don't think that we are going to see miracles.
Thank you so much.
I would like to, first of all, are there any other questions from the audience? Okay, very good.
A lot of cases in the United States are done through mediation. Are there
Mediation, yes.
mediation or arbitration that speed up that judgment process? Does Greece have that same opportunity?
Since 2019, we have a new law about mediation. But the way until now it is implemented is, I think that the results are not very satisfying. We have a procedure before a hearing that we have to have a conversation with the other party to be informed that we have the possibility for a mediation. But this hasn't caused a significantly raise of the number of cases which are resolved in this way with mediation. We have to make more efforts about it, but I think it's, one more time, a matter of mentality. But we have to see not only procedural ways to increase the number of cases to be resolved by a mediation. In this working group, we're trying to figure out what could do to change the situation.
Thank you.
I would like to add a couple of brief comments which could also act as a question. The first one is a little bit inappropriate in the sense that we are talking about the huge problem in Greece of justice system being extremely slow, but I would like to add that sometimes it can really speed up things. And,
yes, of course.
This raises questions. For example, in our defamation case, We published the article in August 2022, and we got our first trial date 3 months later. Very fast, very fast. The person that sued us was at that point the General Secretary of the Prime Minister, etc., etc.
I know.
I'm making the comment because now we are almost 2.5 years, almost 2 years after this lawsuit, and still in this surveillance scandal, the people that were involved have not even been summoned as witnesses. So the journalists were brought in court, were tried again and again and again for a defamation lawsuit that, according to international press freedom organizations, is a typical SLAPP. But at the same time, the people involved in the scandal have not even been summoned by the judicial system as witnesses. So there is this peculiar asymmetry when it comes to the pace of the justice system.
I understand. I agree with your remarks. But we have to point out that these are two different parts of the judicial system. Is the penal part and the civil part. They are not connected in a very tight way.
And although we are a little bit delayed, but I just wanted to add one thing in a little egoistic way because it concerns the journalistic community. One of the abusive practices, in my view, is that we've reached this point when even before you publish your story, just because you file questions to the person involved in the story, you get slapped. And actually, I go back to what you said about the mindset being about protectors of freedom of speech, that in this case, the speech has not even been spoken. The information is not even out there in the public domain. And the other person, it can be an entity, it can be a company, it can be a politician, it can be a business person, is attacking with a slap just before you filed a question. And I would just want to ask you if you think this could be considered as an abusive practice.
It is an abusive practice, but beyond SLAPP suits, there are many other cases that we have also have under consideration. For example, I publish an article that says that I am a rapist, that somebody is a rapist. It is very hard for that person to be innocent. Even 10 of decisions are say the opposite. So we have to see a balance. The power of press is very big. Not only press in the traditional way of Facebook and all the social network. We have to find a difficult balance, and that's because I'm very skeptical about characterizing a lawsuit as a SLAPP suit. Is a very difficult decision, and it is very difficult to see it in a very in early stage, as the directive says. It is something we have to take into consideration.
Okay, thank you very much. So I would now ask Mr. Koukakis. So Thanasis Koukakis, as I said before, we stay here. You prefer to go there or to stay? No, that's okay. He prefers the desk.
In order to have a more vivid interaction.
So a small just presentation about Mr. Koukakis. As I said before, he is everything. He's a reporter. Something that people do not know, that he has been also a source for much of the reporting in the surveillance scandal. The outlets, including us, that reported on the surveillance scandal were in many cases based on information or in previous research that Thanasis has done, and this is very important to give him the credit for it. And finally, he has been a double victim, a victim of surveillance, of predator, and at the same time, a victim of abusive lawsuits, as we said.
I would like to thank the organizers for having me here. I will not speak about Savela scandal at all. I will try to stick on the topic of our agenda, and I would like to highlight something that is very important and that had been too highlighted about the journalist sources. We are talking about the whistleblowers, okay, and how all the SLAPP pressure interacts to them too. Okay, so SLAPPs, it's not something aggressive, abusive that have to do with our job, with journalists, in order to stop us from revealing things, wrongdoings. It is very relevant with our sources. So imagine when SLAPP has to do with reducing my credibility and reputation as a journalist, when SLAPP had to do with delay or prevent the information that have to be published, or when SLAPP, something which is very common, aiming to cause a self-censorship, okay, because I will be afraid, so I will not be eager to reveal the things that I already know. So those things, in an indirect way, had an impact to my sources too, okay? Because when a person trusts you something very sensitive in order to publish that, and you are not publishing that, at the same time he finds himself to be in a very fragile situation, okay? He is totally insecure. He did not know whether you utilized his information. Are you doing that for your own good, for your personal sake? No. Or are you trustworthy? Are you going to betray him? Okay, so there are many things that have to do with our sources and the whistleblowers. When you're reporting in a very high level, and you have to, and because of your position, you're a well-known journalist, okay? You're working for a very famous, well-known media abroad. I have to collaborate with CNBC, with Financial Times, Al Jazeera, and always in a very difficult stories. The people that were my sources have this perception that they will always be secured. So, and their first security is their truth to be published. The things I have given to you to become a public knowledge. So when this is happening, there is a salvation for them, because there is a fulfillment of the things that they have already given to us, trusted to us, okay? So through SLAPPs, the people that they target journalists with SLAPPs, one of their aims is to send a message to the sources of the journalists, okay? And in order to correlate it with the Savela scandal, it wasn't the journalists the target, it was the people that were talking with the journalists, okay? So the deep state wanted to know who are my sources, and who are the people that I'm speaking with, who are the ones that making, leaks. So through SLAPPs, as Nikolaos told you, I was not directly, I was not author of no one of the stories that have been already been published about the surveillance scandal. But despite that, I have been slapped with 3 different lawsuits.
for retweeting the stories, the initial stories. So imagine, is this abusive? Of course it is, okay? In the Twitter sphere, it was approximately 30,000 people that had made the same thing that have already made, okay? They were tweeting the story. But why this specific person decided to file a lawsuit against me for just retweeting the story? So this was the reason that I asked Mr. Giannoulas about the early stages judgment about the SLAPP lawsuits, because if we implement the SLAPP directive, something that we have to do until the 7th of May of 2026, that will be, a relief, because the judgment of the Greek judicial will be that this is abusive and have to be dropped off in early stage. So I have a personal interest by asking you. So I don't want to take more from your time, just to highlight this very sensitive aspect that SLAPPs are not targeting just journalists, they are targeting our sources too, because if they succeed to their goal in order to mute us, then the sources will be less eager in the future to provide them information, and by doing that, they have succeeded. There will not be any whistleblowers. There will not be any original sources, and they were going to have the full control of any situation. Okay, so if you have any questions, I will be eager to answer them.
First, okay. Thank you for this. It's actually an eye-opening to see the situation in Greece and what journalists go through when it comes to freedom of expression or speech. I keep saying that one of the journalists' mission is to amplify the voice of the whistleblowers. I come from a background of electronics, so I'm thinking electronics. So, you need a good amplification, a boombox, to amplify without distortion, though. So the truth has to come out. It's very important for the sources to be heard, especially when they feel like that they don't trust justice. So, and that is what we say, and under the European directive, we're saying external disclosure. That's what the directive allows us to have external disclosures. So, and essentially, I've read it's in black and white. It allows you to go via an external disclosure, even via a journalist, when he or she feels that there won't be any chance to be represented, by internal disclosure. That means going through the, judiciary process. So that's very important to understand. Now, on the other hand, balancing the story is also very important. Okay, I have personally been crucified by my previously disclosure in South Africa. So there has to be a balance, and there has to be two sides of the story. So there is a sacred relationship between journalists and whistleblowers, and there is you as journalists have a big burden, okay, and a duty to consider that amplification and what the impact it will have on the lives of whistleblowers. I don't know if you can understand what I'm saying, that you have to make sure that you don't want to just tell the story, okay, but you also want to make sure that you don't place those journalists under threat. I'm trying to understand, how is it possible to sue you because you retweet something? That's something I need to understand myself, and I think everybody here needs to understand that. I can retweet something.
Mr. Giannoulas, he is the one that he had to answer that.
It is a characteristic case of abusive behavior. I cannot understand what makes the retweet of Mr. Koukakis something more significant than my retweet for the same. It is not related I cannot find something legally important in the behavior of Mr. Koukakis. Just for retweeting that. Just for retweeting.
Thank you.
Well, I can explain why he was a victim of this abuse. There was no legal reason whatsoever. It's very simple. He was a threat. He was seen as a threat, and this is why he was targeted. He's a dangerous guy. But I wanted to add, try to show how extended is the problem in Greece. Because Thanasis, it's very important that he made a big point about the protection of sources in Greece. So we have Thanasis Koukakis being surveyed by two systems, the legal AIP, National Security Agency system, and at the same time, and when I'm saying at the same time, I'm saying literally at the same time, from an illegal spyware that us journalists have connected to the Greek government. I'm not sure they cared so much about him, but I'm sure they cared about his sources. Then, Stavros Malichoudis, working for Solomon, doing story on migration. We know for a fact, because we've seen the report by AIP, that he was also surveyed, again because of his sources. My colleague Tassos Teloglu, working for Inside Story, not on the surveillance scandal, while he was up in the mountain reporting on wildfires. Why would AIP survey Tassos Teloglu for the wildfires? Because he was talking to many different people. So again, it was about sources. My close colleague, Thodoris Chondrogiannos, working for Reporters United, we do not have evidence, but we have strong indications because it comes from a very reliable source that while we were reporting on the surveillance scandal, the security authority, whatever, AIP again, tried to triangulate his position on the map to connect it to the sources to which he was speaking. So they were not surveying the content of what he was saying. Maybe they did that too. We do not know. But we know that while he was sitting in a cafe in a suburb of Athens, let's say in Glyfada, they were able to locate the people who were sitting at that cafe with him using a special application that creates a tree of his connections. So it's not about the journalist, it's about the sources. That's why it is so important.
Yes, in order to close that, public participation. Public participation is the one thing that can cause transformative impact. Okay, so this is the aim of the SLAPP directive, is to protect and encourage public participation. And this is the message that I want to send, okay, that we are here to safeguard public participation. Okay, thank you.
Which leads us to the last speaker, probably the best one, I would say. Janine Louloudi, my colleague from Reporters United. I think it's very relevant with how Thanasis closed his remarks, because this is well connected to the issue of protection of sources. I'll just say a small anecdote before Janine starts, because she's about to present us something for us has been very important over the last years. When we launched Reporters United as a small investigative network of investigative reporters in Greece, the first day that the homepage was on air, was online, it had a banner saying, there was a banner saying Greek Leaks, the first whistleblower for journalists in Greece, and then there was a small sign saying, coming up soon. So this website went online in November 2020, and everybody was asking us, how soon is this coming up soon? And we were saying it's a matter of a couple of weeks, maybe a month, and now it's 4 years after. And coming up soon took us 4 years, but at least today the platform is live, and I suppose this will be one of the issues that Janine will talk about and present.
Hello. I'm sorry, you're going to have to bear with my voice because I'm a bit sick. I think I got a call to the Data Harvest Conference where we were 2 weeks ago, and everybody, part of the panels that were discussed there, it's a journalism conference, had to do with whistleblowers and SLAPPs. So we talked a lot about the protection of source and SLAPPs, and here at Reporters United, our team of journalists, both because of the nature of the stories we work on, which focus a lot on corruption, abuse of power, both in the public and private sector, and of course public interest, protecting our sources has been at the heart of what we do. So a while back we started an internal discussion on the need to give access to potential whistleblowers to our team, and in a way that would provide both anonymity and safety, but also a way that would be as inclusive as possible and would take into consideration, on one hand, the level of confidence that people, potential whistleblowers, have with technology, the type and volume of information that they would want to convey to our team, and also the nature of the persons or entities who would have an interest in preventing the information from becoming public. So possible adversaries and people who would try to stop the process of leaking information to journalists. This internal discussion, as Nikolaos said, took a while, but eventually it started bearing fruits. It evolved into a full-time project, which developed over the last 2 years, because there were a lot of technical difficulties to overcome and specific requirements that needed to be satisfied. But the result is finally here today on our online platform, GreekLeaks, and you can be the first to check it out. I think if you can show it. Yeah. It's here. You can visit it on reportersunited.gr/GreekLeaks. We will be doing a soft public launch on social media next Monday, June 17th. Before I say more about it, I will say that what is GreekLeaks? It's a platform that will allow citizens to send messages, information, and all kinds of material, documents, video, audio recordings, photos, etc., anonymously and securely to Reporters United. This can happen using 4 methods, and on our landing page we provide specific guidelines that need to be followed so that communication between whistleblowers and journalists remains anonymous and safe, and also some tips and things that we have carefully deliberated on and think will help towards that end. So the 4 communication methods are the traditional mail via post service to secure post office box, a dedicated number on the Signal phone app, GPG email, Proton Mail, and most importantly, the SecureDrop open source whistleblower submission system. SecureDrop is a system that was originally created by the Freedom of the Press Foundation, where, for anyone who's aware, Edward Snowden used to be president, right? And he's a member of the board of directors. Through SecureDrop servers, anyone can securely send us encrypted messages, information, and files without the recipient knowing the identity of the server or details such as IP addresses or location. We will only know a date of submission and a code name of the potential server, but no other indication of who that person, who the whistleblower is. The communication happens over the Tor network, while for additional security, all submissions we receive are decrypted on an air-gapped device that is isolated from both the internet and our internal networks. Messages and attachments are all encrypted, and only accredited users of the system will have access to decryption keys. So it sounds a bit hard to use, but if you follow the guidelines, it's pretty easy, actually. Today, SecureDrop is used by some of the world's leading news organizations and investigative journalism platforms like The New York Times, The Guardian, Mediapart, ICIJ. And prior to GreekLeaks, however, there was still no platform in Greece allowing whistleblowers to securely share information with journalists. So how did we do this? As Nicola said, it took a while. We wanted to create this platform and make it as open and accessible and transparent as possible for anyone, both to use but also to review the technology behind it, and safeguard the privacy of the communication process with whistleblowers. To that extent, we collaborated with two main partners. In Greece, with the Open Technologies Alliance, ELAC, for all of you knowing ELAC. They helped us develop, they offered legal and technical advice, and they helped us develop, test, and evaluate the idea externally. And we also collaborated, especially on SecureDrop, but also on Signal, with the San Francisco-based Freedom of the Press Foundation. They have developed the protocol for SecureDrop, and FPF has reviewed carefully every step of the process. And we're happy to say that we finally got a green light 2 days ago to be included in the global directory of media organizations that have active SecureDrop instances. This will be jointly made public next week. And Greek Leaks, finally, is not just technical aspects, it's also what comes after receiving and decrypting information from whistleblowers who want to communicate with Reporters United. There are a lot of challenges there, both ethical, methodological, and we have thought of the position both the whistleblower finds themselves in when deciding to leak information, but also the trust that they put in us. So with our partners, we've discussed this thoroughly and have developed a protocol of careful steps and specific actions that we have to adhere to, especially the dedicated team members that will have access and manage Greek Leaks. And will then have the task of looking into the information provided. Reporters United is also committed to following the Perugia principles as a code of conduct for working with whistleblowers. And we understand that this will be a challenge from a journalistic aspect, but we're happy to take it on, I think, maybe. And hopefully ensure that information of public interest can make its way to the public without jeopardizing both the identity of the whistleblower and compromising the essence of the information they provide.